to examine pure legalistic angle. This can be achieved even without bending, much less break rules of interpretation. In the Council of Ministers under 356 has all will also be within the judicially discoverable and manageable standards. So that's the first paragraph. Then 106 PDF 119. Thus the federal principle, social pluralism and pluralistic democracy, which forms the basic structure of our constitution, demands that the judicial review of the proclamation under 356 is not only an imperative necessity, but a stringent duty, and the exercise of power under the said provision is confined strictly for the purpose and to the circumstances mentioned therein, and none else. That's very important. The purpose of 356 is to restore democracy. That is why this is very important. So you must interpret whatever the actions of the government are in the context of that purpose under 356. It also requires that the material on the basis of which the power is exercised is scrutinized circumspectly. In this connection, we may refer to Dr. Ambedkar, what he had to say in reply to the apprehensions expressed by other honorable members of the Constituent Assembly in this context, which also brings out the concerns weighing in the mind of honorable members. In regard to the general debate which has taken place, in which it has been suggested that these articles are liable to be abused, I may say that I do not altogether deny that there's a possibility of these articles being abused or employed for political purposes. So this is not something that I am saying on my own, Mullah. This was envisaged. But that objection applies to every part of the Constitution, which gives power to the center to override the provinces. In fact, I share the sentiments expressed by my honorable friend, Mr. Gupte, yesterday, that the proper thing we ought to expect is that such articles will never be called into operation, and that they would remain a dead letter. If at all they are brought into operation, I hope the president, who is endowed with these powers, will take proper precautions before actually suspending the administration of provinces. I hope the first thing that he will do would be to issue a mere warning to a province that has heard that things were not happening in the way in which they were intended to happen in the Constitution. If that warning fails, the second thing for him to do will be to order an election, allowing the people of the province to settle matters by themselves. It is only when these two remedies fail that he would resort to this article. It is only in those circumstances he would resort to this article. I do not think we could then say that these articles were imported in vain or that the president had acted wantonly. Time and again in the history of this country, 356 has been misused by all regimes. That was never the intent. And now, in this, in changing the structure of this constitution as applicable to Jammu and Kashmir, it has crossed all limits. See what happens. 20th of June, Maharaj, 19th of June, sport withdrawn. 20th of June, governor says, and suspended animation. 20th of November, an attempt is made. Well, there is some ambiguity in that, to form a government. 21st November, dissolution. Can't be done without the aid and advice. Then, after 21st November, 19th December. Then 356. Then 3rd of July. Extended. Then 5th of August. Where are the steps for the restoration of democracy? Where are those steps? In fact, the steps are just to the contrary, the reverse of it. Destruction of democracy. People are not taken into account. Their views are not taken into account. You arrogate to yourself the powers of the state. You arrogate to yourself the powers of the legislature. Parliament becomes the spokesperson of the people of Jammu and Kashmir. And you express the wishes of the Jammu and Kashmir Assembly through Parliament. when the Constitution requires you to take the views of the state, of the legislature, of the people of Jammu and Kashmir, who gave to themselves the Constitution of Jammu and Kashmir. Everything that is done under 356 is contrary to the basic principles of both federalism and democracy, and to the principle of constitutional morality.
Yes, please.
Then 108 minutes. The further equally important question that arises in this context is whether the president, when he issued the proclamation under 356, would be justified in removing the government in power or dissolving the legislative assembly, and thus in exercising was, for example, only assumption of some functions or powers of the state, government of the state, or of anybody or authority in the state under 356(1)(a). This is not the only power that you can exercise under 356. There are incremental steps to be taken. This is not a guillotine provision. And it's temporary, to say the least. So unless your lordships come down heavily, that 356 is that it's just not possible, affected by the present governor under 164, 174, respectively, under subclause A of Article 356, though that is neither necessary. Subclause C of exercise of powers of the legislature of the state by or under the authority of Parliament. What is further the assumption of only some of the functions of the government and the powers of the government, its powers are exercisable by or under the authority of Parliament. The word permissible under 356, firstly, only to suspend the political executive or anybody or authority in the state, and also the legislature, and not to remove or dissolve them. Say this really. And then, sorry, the last paragraph. However, whether in a particular situation the extent of powers used is proper and justifiable, the question which would remain debatable. Just pause here. Whereas on the 21st of November, the governor had no power to dissolve power. Could only do it under the and then the governor, did what he did. You impose 356, and then you take over the powers. And ultimately, you are a delegate. 356 delegates the powers of the legislature to you. You're not an omnipresent, omnipotent authority to do what you like. You're a delegating. You've been delegated the powers of the legislature. What the primary institution cannot do, the delegate cannot do. So therefore, 356 was an extraordinary provision, allowing a progressive pathway for restoration. So what does that have done with this? Then,
Mr. Sibal, you can perhaps give us the paragraphs. You can read them if they are on the same drift.
yes, I do.
Just give us the paragraphs so that we'll read them later.
I'll give you the paragraph. Volume 2. Whereas therefore there's Justice Jeevan Reddy.
Which paragraph?
268 and para 289.
Paras 268.
289, PDF 225. 268, 289, para, PDF 225.
Right.
Then Justice Ahmadi, PDF 69. PDF 69, paragraphs 14, 16, and 23. Right? Yes, the rest I've read. This is what, yes, yes, the rest I've read. So this completes.
Yes, yes. What is the next judgment now?
No, we've already read it. Well, yeah, there's a speech of Ambedkar on constitutional morality, which I just want to mention. That is November 1948. compilation volume 8. I'll just do that. Document compilation volume 8, PDF 3. Oh, sorry. 15. Sorry. Right.
I think I cited it in the first Delhi judgment, the NCT judgment 2018. Document compilation 8 page.
Page, Madad's 15, PDF 15. Running page 2876 at the bottom of it. Yes, it's also quoted, Madad, in the Delhi matter. So my lord doesn't, it's all right. We can move forward. So, Madad, this is now, I've done with 356. We'll give your lordships the pages of the Delhi judgment also.
Yes, you can just give that.
Paragraph 284.
Where is the Delhi judgment? NCT?
Yeah, I just give your lordship the citation. Volume 5.
Case law, right?
Case law compilation, volume 5. PDF 2, where it starts. At paragraphs 284, 303, 284, 303, PDF pages 146 and 159. So PDF 146, 159, paragraphs 284, 303, right? So that's the Delhi judgment. Then, Madad, I want to cite to your lordships Miller's judgment. That's important. I'll just give you 3 paragraphs of Miller's to just show where it is.
Yeah, it's volume 6.
Volume 6. Volume 6, PDF 384.
PDF?
Sorry. What was my mistake? I'm sorry, but it's my mistake. Sorry. Volume 5, it is not 6. PDF 308, volume 5. And I just 3 paragraphs of that judgment that I will assign.
Volume 5.
Only 5 page number?
It's
308.
PDF page 30. It's a PDF page 323 of volume 5. Straight to the paragraph that I'm reading.
Yes.
323, para 41. PDF. This is the case where the Queen was advised to prorogue Parliament. And 11 justices came down heavily, unanimous judgment. You can't just shut away discussion in Parliament. This is an extraordinary Malad's interpretation, showing that, look, you can't just show your back to the constitution, to the constitutional authority which has to deal with these issues. In our constitution, the right to prorogue is also given to the government. But of course, this principle is not really applied often. Now, C41, 2 fundamental principles. All your lordships have it. I'll read it. PDF 323. 5.
323.
I'm sorry?
320?
323, madam. Running page 1446 at the bottom. I'm just waiting for Justice Kaur. Two fundamental principles of our constitutional law are relevant to the present case. The first is the principle of parliamentary sovereignty. That laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply. However, the effect which the courts have given to parliamentary sovereignty is not confined to recognizing the status of the legislation enacted by the Crown in Parliament as a high, to silence them through your own acts or majoritarian rule, which is a political act, according to me. To give only a few examples, in the case of proclamations, the court protected parliamentary sovereignty directly by holding that prerogative powers could not be used to alter the law of the land. Three centuries later, in the case of Attorney General versus Kaiser's Royal Hotel, 1920 appeal cases 508, the court prevented the government of the day from seeking it by indirect means to bypass parliament in circumventing a statute through the use of prerogative. Exactly what's happened, Mullah. In fact, much more, circumventing the constitution.
So, Sibyl, in a similar discussion we'll find in 7 Judge Singh.
Yes.
On the power to enact, to promulgate ordinances. Yes. And the question was...
Your lordships have said.
Yes.
In that judgment.
Can you, though the power is limited by duration and time, can you bring about irreversible changes by the exercise of the ordinance making power? And we said you can't do that.
I've relied on that. Absolutely. If it were an act of parliament, right, Malaj, the situation may well be different. Because then you would have to attack the legislation itself, if at all it is permissible. But you're not, you're doing something through your prerogative power. And making structural changes in an embedded constitutional structure recognized by Parliament then in 1950. That's the problem in the case. 326.
Actually, para 50 is the...
So, just 50 is important. It's a very small paragraph. I'll just read it. At PDF, page 326. It says, for the purposes of the present case, therefore, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as a body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional clause. Anyway, so that's I'm done with Mr. Krishna Kumar, I'll give the citation only because it's your lordship's judgment.
Is it part of the compilation?
It's volume 21, Mullah. Yes, it starts at PDF 2 at that volume, in that volume, volume 21. And the relevant part, PDF page 82, paragraph 101.
Para 101.
Para 101. And 103, repromulgation in the present case, as well as 103. And that's PDF 83. PDF 82. So that's Krishna Kumar for your lordships. So that's, we've done with this. So this topic now we've done with. Now let's come to Mullah. That's that itself. I've said that. 356 is only for temporary emergency legislation. Anyway, Mullah, so now we come to Mullah, the judgments, because several of the judgments in JFK have interpreted these provisions. So I just want to bring, up to speed. Compilation Volume 1.
These are judgments on Article 370 itself.
That's correct. That's correct. Yes, this one. Yes.
Which is the first judgment?
Just give me a minute. PDF page 2, Malas.
Which volume?
This is volume 1 of the judgments, Malas. This is Lakhan Pal versus State of Jammu and Kashmir. First man. I intend to finish today, Malas, so that
Thank you, Mr. Sibal, for keeping to time.
your lordship has been very kind.
I was going to tell you at 2 o'clock when we assemble, but sometimes, as a judge, you don't have the heart to do it.
No, I am very much.
But I'm sure that you will do it.
Already sort of perhaps
Thank you.
tested your patience more than.
No, not at all. Which
Malas, this page, first paragraph.
which page?
Page 1, Malas. PDF page 2. This is a Constitution Bench judgment. Lakhan Pal versus State of Jammu and Kashmir. I won't deal with the reorganization, Malas. There'll be others, other senior counsel will deal with it. But I'll broadly tell your lordships what the summation is. And then they can deal with it more elaborately. The application of a writ of habeas corpus is directed against the state of Jammu and Kashmir, which has by its order dated 4/10/1955 directed the detention of the petitioner under Section 3 of the Jammu and Kashmir Preventive Detention Act, hereinafter referred to as the Act. Originally, the sole respondent impeded was the state of Jammu and Kashmir. After the rule Naisai was issued to the respondent, the Union of India intervened because the petitioner had challenged the validity of the constitutional application of the Jammu and Kashmir Order 1954. Those are the facts, and the order is set out, Malas, as PDF 4.
6.
PDF
Actually, you
Four.
read the order.
Yes, I'm just reading the order.
Attention.
Yeah, that's the order. Whereas the government are satisfied that Lakhan Pal, chairman so-and-so, has a view to preventing him from acting in a manner prejudicial, it's necessary to make the order, and therefore they make the order. Then kindly come to paragraph 4. This order was to remain in force, Malas, for 5 years. But it was extended. The petitioner contended that you can't extend this order. That's how the matter came up. So your lordships will find in paragraph 4, act impugned in this case provides whether before or after the commencement of the constitutional application to Jammu Kashmir Order 1954 shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the order, except as respects things done or omitted to be done. The effect of the modification in 35 is that such of the provisions of the Act are as consistent with Part 3 of the Constitution, shall be valid until the expiration of 5 years from the commencement. This is an exception which has been engrafted on the Constitution in respect of fundamental rights relating to personal liberty for a period of 5 years. The Act itself has a limited life of 5 years, thus exception aforesaid is coextensive with the life of the Act itself. Hence, so long as the Act continues in force in its present form, the provisions of Articles 21, 22, insofar as they are inconsistent with the Act, are out of the way of the respondent, exceeded his powers.